और उसके बाद में क्या होना है. एंड these are fourth instruction issued since April. तो इसी साल में चौथी इंस्ट्रक्शन है from the GST investigation wing. So it is 11 page instructions और आप इसकी गंभीरता को ऐसे ही समझ सकते हैं that 11 pages instructions are there. And first of all they have said that when, as we all know, that we have to go through section 132 of CGST Act for these prosecutions. So 132 में they have come with offences which require criminal proceedings. Now in these criminal proceedings, they are saying that who has to be prosecuted and how this has to be prosecuted. So सबसे important उन्होंने कहा कि that there should be availability of adequate evidence. तो अगर evidence नहीं होंगे या लगता है कि evidence कम है तो prosecution नहीं करना. And those evidence should establish beyond reasonable doubt. देखिए दो वर्ड होते हैं, reasonable doubt या reasons to believe, and second is opinions. तो यहाँ पर जो है they are talking about opinions. जो आपने शायद आपने एक डिसीजन सुना होगा, राधा कृष्ण इंडस्ट्रीज ऑफ स्टेट ऑफ वर्सेस स्टेट ऑफ हिमाचल प्रदेश ऑफ सुप्रीम कोर्ट. एंड उसमें भी यही बात थी that there should be an opinion. So reasons to believe एक बड़ा point है, but opinions has to be firm, solid. So if the commissioner or the principal commissioner has reasons to believe, or reasons should be reasonable doubt, then only a person can be prosecuted. And these will vary case to case. Individual case to case vary होंगे, and these could be for, it could be on the gravity of the offense, nature of the offense, quantum of tax evaded, ITC wrongly availed, या refund wrongly went, and with the nature कि किस तरह से एविडेंस कलेक्ट करे गए. इन सब को देखकर इसके बाद now they have to establish or that there was some positive action from the person to evade tax. So if the case is of a technical nature or where additional claim of tax is based on the difference of opinion regarding interpretation of the law, तो वहां पर अरेस्ट नहीं करनी या अरेस्ट के लिए प्रोसिक्यूशन लॉन्च नहीं करना. देन they have to establish, जो डिपार्टमेंट के ऊपर ओनस है, that they have to establish or the commissioner has to record the reason that the person on whom we are launching this, he is of guilty mind. तो guilty mind यहाँ पर लिखकर चलना है, and that he has knowledge of the offense and he has a fraudulent intention to evade tax. तो ये सब उसकी तरफ से होना है. Then उन्होंने कहा कि साहब, इन केस ऑफ पब्लिक लिमिटेड कंपनीज प्रोसिक्यूशन शुड नॉट लॉन्च अगेंस्ट ऑल द डायरेक्टर्स. तो पब्लिक लिमिटेड कंपनीज के केस में उन्होंने कहा भाई सारे डॉक्टर्स को पकड़ने की जरूरत नहीं. द पर्सन हु इज रिस्पॉन्सिबल और हु इज सीइंग डे टू डे ऑपरेशंस ऑफ द कंपनी और हु हैज टेकन एक्टिव पार्ट ऑन टैक्स इवेजन, सिर्फ उसके अगेंस्ट प्रोसिक्यूशन करना है, सबके अगेंस्ट नहीं करना. देन we go with the Supreme Court decision in Radheshyam Kejriwal. This is 2011 decision which they have quoted in the instructions itself, and they have said that adjudication proceedings and criminal proceedings, these two are different. आप ये नहीं कह सकते कि साहब आपने मेरे अगेंस्ट क्रिमिनल प्रोसीडिंग्स लॉन्च कर दी, अभी आपका एडजुडिकेशन कंप्लीट नहीं हुआ. सो दीज वर द ओल्डर लॉज, सर्विस टैक्स एंड इनडायरेक्ट टैक्स एरा, जहां पर एडजुडिकेशन के लिए कोर्ट ने कहा था. लेकिन यहाँ पर आपका जीएसटी लॉ कम्स विद अ डिफरेंट लॉ और डिफरेंट स्कीम. नाउ व्हाट इज द मॉनेटरी लिमिट? नाउ दे हैव सेड दैट द मॉनेटरी लिमिट, एज यू ऑल आर अवेयर, इट इज 5 करोड़. सो 5 करोड़ से नीचे आर द बिलेबल ऑफेंस, 5 करोड़ के ऊपर वाले आर द नॉन बिलेबल ऑफेंस. Then, but this limit does not apply for the habitual offenders. If the person is a habitual offender, तब आपके लिए 5 करोड़ की लिमिट नहीं होगी. दिस वुड बी फॉर टैक्स इवेजन और फ्रॉडलेंट रिफंड और मिसयूज ऑफ आईटीसी. नो, जीएसटी लॉ में कहीं भी फ्रॉडलेंट हैबिचुअल ऑफेंडर की डेफिनेशन नहीं दी हुई. सो फ्रॉडलेंट हैबिचुअल इवेडर की डेफिनेशन पहली बार यहां पर आ रही है. एंड दे आर सेइंग दैट द habitual evader is the person who is treated as a habitual offender in more than 2 or more cases of the confirmed demand. Adjudication level पर उसकी confirmed demand हो चुकी है and the amount is more than 5 crore rupees, 5 crore or more. Now who is the authority to sanction prosecution? सवाल ये भी आता है कि भाई prosecution के लिए power sanction कौन करेगा? तो principal commissioner or the commissioner of CGST will sanction this power. They are the sanctioning authority. Other than these, no one else. But in case of intelligence based investigation, now अगर DGGI investigate कर रहा है, then the principal additional director or additional director general or director general of DGGI, these would be the authority. Now, what is the procedure for prosecution? The procedure is that arrest has to be made under Section 69 with report has to be submitted, FIR has to be filed within 60 days. और इसमें उन्होंने कहा कि भाई 50 days में आप हमें डिटेल दे दीजिए so that we can file those. And in case of, see, it is on the legal entity. Now the offense has been committed by the company. Then who has to be prosecuted? So they said that when the crime was committed, so whosoever was responsible for tax filing or who is the one who has evaded tax, so those will be the person against whom this prosecution would be launched. Now, there is an issue. कुछ लोग कहते थे who has to prove whether the act has been done with his consent or not, connivance or not. So they say that both cases we are going to prosecute whether the consent has been of the person or not, connivance has been or not, and they could be a director, manager, secretary, or any other officer. Even for negligence, अगर उसकी negligence से भी tax evade हो गया, then also they are saying that we are not going to give permission for, we will try to prosecute. Then how this will be further, how these things will be taken care of? So they say that the person who will adjudicate, they will put up a file that this is the file, and then the principal commissioner or the commissioner from DGI would, director general from DGI will record the reason and then give permission. If they have filed the file and within 15 days no action has been taken or the sanction is not provided, then they have to request for again for prosecution if they feel so. Now within 1 month they will prosecute the person. Now in case they prosecute a person but later on with certain evidence they find that the person is not guilty, then there are details for withdrawal of this prosecution also. And then there are guidelines how they have to, once a person is arrested, now he might be requesting for bail. So how these will be taken care of, and if the person has got bail, then whether department will file appeal against that bail. So all those provisions are here now, and this is a very detailed guideline which everyone should follow, and you should all go through this 11-page instructions. With also one more thing, that name of the person who has been prosecuted has to be published as per guidance in as per scheme of section 159. So section 159 speaks about who has the power. So those powers has to be checked again. Thank you. Thanks a lot. Hope you like this. Thank you.